right. Good evening, everyone. My clock is showing 6:30, so we'll go ahead and get started. I want to welcome everyone to night four of Securing the Future Legal Audits for Farm Families and Agricultural Success. Um, Tonight's session will be on operating and buy-sell agreements. We're really excited to be bringing this program to you. This program series is part of a USDA NIFA funded grant that's allowing us to develop this legal audits program series and some other helpful material. Um, to get us started, I am going to launch a short demographics poll. It is anonymous, completely, you know, welcome to anyone that wants to fill it out. Um, and it just asks three questions about how many people are watching this at your location, and then some different demographics information about race and ethnicity, for everyone. This is just for our reporting purposes and helps us answer some questions and report back to USDA NEFA. So we'll leave it up here for a couple more seconds here. So as a reminder, all of our sessions are being recorded so that you can watch them at your leisure at a later date. For tonight, we will be using the chat feature. So if you have questions, please feel free to put them in the chat and we will answer them probably towards the end or whenever they take a break. But without further ado, I'm going to introduce tonight's presenters. We have Ed Ferris with Purdue Extension in Huntington, and then Scott Lineweber. Scott is a shareholder attorney with Eagle and Field. Hopefully I pronounced that right. But thank you both for joining us. I'll turn it over to you.
Okay, well, welcome everybody. Again, I'm Ed Ferris. I'm with Purdue Extension. I'm Ag and Natural Resources educator in Huntington. Also specialized in farm management. Been a part of the succession planning team since we started, which is since I think about 2011 or so. We've had this team in existence and uh, really appreciate working with Renee Wyatt, also a specialist to put this presentation together along with Scott Lineweber. Scott and I have actually known each other quite a few years. We grew up in the same neighborhood, so fun to actually do a presentation here tonight with Scott. Um, and we're both from originally from Southwest Indiana, and I've been here in Huntington County for the past 18 plus years, working in extension. And so we just wanted to start this off. I'm going to start off the presentation, making sure that I've got control here. Make sure I can move. Okay, make sure my something's wrong with. Okay, here now I've got it. I think I can find my control here. Okay. Yes. And so sorry for that little blip, but we did want to just mention first that our this is part of a grant for the North Central Risk Management Association, North Central Extension Risk Management Education, and this we actually have worked with this organization for many grants over the years, and so this material is part of this funding is to allow us to share this with you without a charge tonight is because of this grant that we received, and so we did want to make knowledge of that this material is supported by ultimately United States Department of Ag with NIFA, National Institute of Food and Agriculture. So this is important to know that we do have this support behind our work that we do in extension. So to start off with, I'm going to talk about buy-sell agreements and just to give you an overview of things, and then I'll switch over to Scott My background is with agricultural lending before I came to Extension, and I have had a lot of whenever I was starting out, which was around 35 years ago as a loan officer, did Mitch, I see some of these benefits when you go down the list and think about why people should get involved with a buy sell agreement. And I think every time we used to in the days when I worked in Western New York as a lender, we had a lot of dairy farms that would come and they'd have two people, sometimes brothers or something. A lot of times they just form a partnership, go down the road. Well, a lot of times that's a good lesson that they learned at the end of the whenever things eventually had to split up from that partnership. That they sometimes didn't always agree on how to split the assets up. So you can see that when they start, everybody is on board with things, but sometimes that continuity doesn't always continue whenever you actually have to transfer the business with due to somebody's passing or whether it's a disability or whatever happens. But having that, continuity is important. And just, looking at from the perspective of if you need to have creditors that are involved with you as you expand businesses, sometimes it's important to have ability to have a good lending relationship and having that also perhaps maybe there'll be more people buy into the business. Maybe you're added more family members, or maybe it's just there's outside people that have worked in the business and want to invest in it that have some capital, and so by having a buy sell agreement in place is very important. And what is critical is that you have a valuation of those interests and how you're going to calculate those interests and making sure everybody's on the same page. And, so if there's other outside parties that are involved besides the main owners, perhaps you have people that are doing the day-to-day work, but there's other owners, and, you want to make sure that there's continuity if somebody is only there for partial time and is a part of the business and then but they're not actually involved with day to day, so they may not truly understand what all is involved with the to keep the business going. And so just having that um, agreements in place to know what's going to happen. And if you don't want somebody that's not really a part of the day to day that dictates what might happen with the continuity there. So looking at that is important. And so we're going to go ahead and talk about the buy sell agreements. It's any kind of joint venture. It's recommended. I mentioned partnerships. Partnerships were popular when I started out in lending, and but these have transitioned out. We've got a lot more limited liability companies. We have corporations that have started, and actually in those days, years ago, we've always had a lot of corporations and some S corps, and so there's a lot of different types of business operations. And even if you don't have you have a very simple operation that it's never too late to implement something to get established. So even if you're just a sole proprietor, and just having something to start with is critical. There's thinking about the other family members that might be involved if something happens with I get death or disability. Or is everybody going to be agree to how the interests are valued? Do you want to have discounts because they're family members? That type of thing is, having that exit plan is very important to think about. Years ago, we'd always say if you were the first one out if you got into a partnership with somebody, the guy that was the first out usually made out the best. And that was because, a lot of times people didn't go through and have everything worked out. So the guy that was leaving sometimes always maybe had the best of both worlds, because they were able to get a large payout, and because they didn't necessarily have, so they had to hammer things out whenever that person left. So thinking about that is very important, and let's go ahead into the next slide. Um, so there's three basic problems, of course. There's a lot of times people don't have a complete agreement put together when you think about this. And well, we'll figure it out. We don't know exactly how we'll do the valuation, but that's a critical step that quite often doesn't always get worked through. And Scott can talk a little bit more about that in a minute with some of the things that he really focuses on when he helps people put these together. So thinking about these minimum things to have is having that, how is it going to be funded? Or does the person, each of you in the business, do you have a good credit history established, or do you have enough wherewithal in your finances that you can get a loan? Is that going to be thinking about those issues and how that might be funded? Is it going to be debt? Is it going to be life insurance? There's other lots of ways that this could be funded if when you get out of the actual business. Um, and then also thinking about the buy-sell agreement, why it is so valuable. Um, and talked about this. Is there going to be a stranger, somebody maybe that is a part of the business but is only there, as a outside owner that provides capital, but maybe doesn't understand everything that goes on as we talked about. Do you want somebody that to overpay that is maybe a family member that's worked, this has been their lifeblood working on this farm, and you want to make sure there's some maybe some special interest given to people that have worked and know that they are respected as a individual and a part of the business, and just having that spelled out as agreement, whether it's between father and daughter or father son, or they want that transfer to happen, and how much do you want to discount, and where do you go to find how you determine how the appraisal is going to be done, that type of thing, and just making sure that the parties are getting a fair shake. You don't want to undersell at the same time, to make sure that there's enough funds for retirement for the people that are uh, uh, associated with the business, that maybe your heirs that are, so sometimes with these larger businesses you have sometimes cousins involved. You don't have just brothers, and that can be more of complicated as you get these with larger farms, and just making sure that everybody's on the same page. So um, just going to go through this slide, and then I'll turn it over to Scott, and let him maybe make a few comments too from the slides that I've already presented. But this is something that I mentioned. It's got 35 years here. We've never had an agreement. Why do we need one now? And that's a very typical response, is that we've always got along. Our families always came to agreement. We've worked things out. Well, things are a little bit more litigious now. There's over 35 years. You may have some family members that have scattered across the country, maybe live in different parts of the country, where they, standard of living is different. They may be further away from the farm if it's truly your typical agriculture or farming operation. Management is just different today. There's increase more volatility. You use more tools now. You think about all the things, people now have crop insurance where years ago, a lot of people, just farm without it. And most farms do have that type of thing. That's those risk management tools that are very important. And this buy sell agreement is just another tool that really is critical for the business to continue in operation and again, just thinking about the credit worthiness, maybe if it's a younger generation, how they can go. Are they going to be able to go out and find a loan, or is there again some other ways of funding through life insurance, that type of thing? So, Scott, I'm going to turn it over to you, and if you have any other things you want to share before we go ahead, I'm going to talk about the provisions next of the that are included.
Yeah, no, you make some excellent points. And by some excellent points, I mean all excellent points. And I think if you really want to think about a buy-sell agreement, it is essentially a prenup for business owners. And what is a prenup? It's an agreement that says who gets what if a relationship ends. And we're all going through this mortal coil, and life is not forever. And folks die, but also, as Ed was saying, there's disability provisions. What if someone can't work the farm anymore? What if somebody just wants to retire and call it a day? So really a great way to think about the buy-sell agreement is like that. It's a prenup for your business. A buy-sell agreement is a legally binding contract, and it's going to dictate how co-owners share a business will be reassigned or sold if they leave the company, face a major life event, or pass away. Without one, a departing owner could sell their shares to a competitor, or a deceased owner's spouse could suddenly inherit voting rights or try to run, the farm. And again, this buy-sell agreement, what we want to happen is we want to make sure there's continuity, and that's what all of this is about. This is just another form of estate planning and making sure that the stuff that you have during life goes to the folks you want to have that, and how you want them to get that, and when you want them to get that. So really, these buy-sell agreements are a critical piece of that, and that estate planning and that business succession planning to make sure that your wishes go through. And so when we look at buy-sell agreements, some common provisions, we're going to identify who the parties are involved, who are those initial, partners or owners of the business. What is the purpose of the agreement, and making sure we're talking about this is, for the orderly transition of business assets at the death, disability, or retirement of the other. There's going to be commitments, and we're going to talk about some of the commitments here that folks can make. We're going to talk about the business interest that is part of this. Certainly, farms can be complex businesses. We know some farms will separate their land and their equipment into different entities. And so we want to make sure when we're talking about doing these kind of succession plans and the buy-sell agreements, we're being very clear on what those business interests are that we're actually, communicating about in these types of agreements. A lot of times we're going to see transfer restrictions, such as rights of first refusal. And we'll talk about those here as we go on in the evening as well. Ed really hit on this, and it's so critical because this is really where people get hung up, are the purchase price mechanism and the funding mechanisms. So what is the farm worth? And for that person who is going to buy out the other partner, the other owner, how are they going to do that? How are they going to accomplish that? And remember, things can look very different if you're buying out in death or buying out in disability. And then, are we going to be able to modify the agreement? Are we going to be able to terminate the agreement? And, we've got an agreement in writing. So, usually we'll say if we're going to modify it or terminate it, it's going to be, in writing, and maybe there's a majority. If there's more than two people, then there's a majority or it's unanimous. All of those types of provisions are real important, and then we want to make sure that that is signed and dated for execution. So the structure of a robust buy-sell agreement really relies on some critical provisions. You could think of it as, who, when, how much, and with what. And so really the triggering events are the things that define the exact circumstances that set into motion the buy and the sell. And that could be death. Disability, again, I think, we all know what death is, and Ed, very wisely talked about, making sure about disability. But some of these other transitions that maybe folks don't think about so often is a divorce. And do we want an ex-spouse to end up acquiring ownership in a business or a farm through a divorce proceeding? Most people don't want their exes telling them what to do. And so, having those provisions about what happens in a divorce are real important. What about a departure? When folks want to retire, or if somebody was a key employee and they get terminated for cause, what does that look like? And then finally, a bankruptcy. What happens to the farm if there is a bankruptcy, that may be a personal creditor issue or something like that, where the farm starts to become business assets that someone wants to seize in a bankruptcy. Another type of provision are going to be the structure and mechanics of the agreement. This is going to be a clause that's going to talk about who is required or permitted to buy the departing owner's share. Generally, that could be through a cross-purchase agreement where the remaining individual co-owners purchase the departing owner's shares proportionately. So if there are four members of that LLC and one of them leaves, then the other three each buy a third of that departing member's share. It could be a redemption agreement where the business itself steps in and buys that owner out, and then proportionately everyone's share just increases equally. Or there could be some sort of hybrid agreement where maybe the company has the first right to buy the shares, or maybe the individual owners have the first right to buy the shares. And then if the owners or the business don't, then the other parties can step in and do that, or offer to third parties. The valuation method, and this is, Ed was talking about this, and we got to figure out before someone gets to a point where they've died, or they're incapacitated, or they're retiring, or getting canned because they did something wrong. We got to know how we're going to appraise that value of that business. And so the buy-sell agreement is going to specify, are we going to use an appraisal method, and especially when we do that, we want to make sure we have an independent person and an appraiser who's used to doing, farm appraisals, making that kind of valuation. And it could be in that agreement that we say, hey, look, we're going to hire one, or if there are, two people involved, then they can each pick their own appraisal and we use an average. So all kinds of different options there when we even use an appraiser. We could always use a formula. So think about multiples of earnings, or what's the book value, or a multiple of the revenue. Those types of formulas could be, set in place. Or you could just state a value. The owners can mutually agree on a fixed value. That can get a little dicey, because what you don't want is to leave the agreement for 20 years, and what used to be $1 million farm is now, $3 million of farmland, or, you've bought other things, or maybe you're in the agrotainment business where, you've got folks coming and picking pumpkins and apples and things like that. So doing corn mazes, all those kind of fun things. So businesses can change over time. And so if you do have that value, you got to think about, what is that and does it make sense? And, even then, making sure it does make sense and thinking about what you want in the end. Some people may say, well, I want my kids to buy it for $1. Well, if you're counting on that farm for your retirement, then maybe $1 isn't going to be enough to get you through your golden years. So again, making sure that that valuation makes sense and how we're going to do that. And so once we know what the cost is, the next thing we're going to be worrying about is the funding mechanism and how we're going to buy that. So, again, Ed was saying life and insurance is real common. It is real common. That is the number one thing that we see folks use. It is super common. Um, and if you have disability insurance, then as well, that disability insurance can help pay out as well and fund the buyout of the person leaving. Some folks will use installment notes. Usually those are structured over 5 to 10 years. And so that way the seller is getting paid out over a period of time, or the heir is getting paid out over a period of time. And then other thing, some folks will, self-insure with the payout, and so they'll use sinking funds or set working capital aside by the business specifically for this purpose, so that when someone leaves or dies or retires, that there is a fund within the company to buy the heirs or the family out. And then finally, another common kind of provision when we talked about the transfer restrictions, these rights of first refusal. And, a right of first refusal is a provision that dictates that if an owner wants to sell their shares voluntarily to an outside third party, first they got to offer those to the people who are actually working in the business right now. That's a very common thing. And then we'll talk later a little bit about tag along and drag along rights as well that can be involved as well. Now, insurance, again, just a note that insurance, is a great way to trigger death. In disability, if you have the disability insurance, the payout in disability, divorce, leaving the business, retiring. Those are a little trickier. And so usually those types of triggers for leaving would trigger something more like an installment payout because insurance isn't going to cover just, I don't want to do it anymore.
We'll go to the next slide, Scott.
Yes, I was just going to say, and if we can go to the next slide.
Okay.
And, the use of restrictive agreements. Family farm businesses have limited market ability by definition. Most, though, will further restrict the marketability of co-shares or co-owners through purchase options and mandatory buyout agreements. And so while a buy-sell agreement is fantastic for protecting existing owners, it can contain certain restrictions that act as huge red flags for outside buyers. And so if somebody wants to put in restrictive agreements into their buy-sell, it is just, you want to be cautious in putting in things that are too restrictive. So, for example, with a right of first refusal, right of first refusals are great because that says, hey, before I buy, I sell to a third party, I've got to make sure that my partners are okay with that, and they don't want to buy me out because they don't want to work with someone they haven't met or know. But what you want to do is make sure that those aren't so rigid or difficult to negotiate, or giving a current owner a right that comes up at the very end. And if you think about Someone purchasing a farm, they're going to want to do some due diligence and they're going to want to look at financials. They may want to look at, the market itself, what other land is going for at the time, what the equipment is valued at. And if someone is going to have to go through a rigorous due diligence process, we don't want them to, have to look at the business for months and months and months, then put in an offer only to have that quashed within, you know, 30, 60 days later and find out, well, I can't buy it after I put in all this work. Um, some agreements will state that an owner can't transfer or sell to anyone without a unanimous or majority consent of everyone else. Um, and that can sometimes provide a permanent veto over an exit strategy, locking you in. So that, again, mandatory approvals can be great, but there are some drawbacks to that as well. Um, Valuation formulas can be a problem, especially if you're using a set value and it's nope, I get to buy you out for $1 million, and now that business, that farm is worth 3 million. Well, that outdated valuation formula is going to really impact um, buyers and other parties involved in that. And then, we talk about tag along and drag along rights. And what a tag along and drag along rights is that if a majority owner is going to sell to an outside party, then with tag along rights, the minority owners can say, yes, I would also like to sell my minority interest at that same amount. Or drag along rights is where a majority owner says, all right, I'm selling, and now minority owner, you have to sell as well. Sometimes those forced drag along rights, while they're meant to facilitate a smooth business sale, if they aren't drafted correctly, and you would want to seek legal counsel, of course, to really do any of these types of agreements. If it's poorly worded, then minority owners can really be unfavorably treated. And then, when we talked about the payout in these agreements, where especially for folks who come to divorce, um, if the agreement is properly drafted, then what you don't want to do is turn an unfavorable divorce provision into an unfavorable new buyer provision. And we've drafted things before where we'll do them as a 20-year payout, so that a divorcing spouse says, this is not an asset that I want any part of, because I'm just never going to see my money, or this money is going to be so small it's going to trickle in forever. And what you don't want to do is have that sort of zombie partner risk um, then tagged on to somebody who is a legitimate purchaser.
Well, ready to go on?
Yeah, yeah, we can go on. So because family farms often are used as a mean of transferring value, bargains at less than a fair market value, the IRS does require in closely held businesses valuations. Okay. When it comes to valuing the interest in a closely held business, a family farm like that, the IRS is not going to allow owners just to guess. And that's been, we've worked with other businesses where somebody has come in and, the accountant says, well, this is what we think it is. And, we always caution them, just some guess is not going to work. The IRS is not going to like some guess. So we want to make sure that that when we talk about valuing the business, that we are really talking about making sure that the fair market value is being used and how the valuation should be conducted. So, key considerations, will include the condition of the business at entry or exit date, the influence of market conditions. That's, farmland that's, off of 69 or here in some of the donut counties are going, may have a very different valuation than that same tract of land in Switzerland County, for example. So, the market can really influence what that valuation is going to come up as. And, I can just tell you from my own family farm, my brothers were buying some more land and they had some folks who had inherited the land from out of state. And sure enough, they came to negotiate the price, and the folks from California were thinking, "Hey, look, this is what I've seen land going for in Indiana." And well, not where they were buying and not, what the condition of that land was. So folks have to be cognizant of a true and actual value. And really business valuation, it's not a precise science, but really an informed judgment. And ultimately, what we got to think about as the ruling anchor in every valuation is a process that assumes a hypothetical willing buyer and a hypothetical willing seller. And so you can't value the business based on what the current owners think it's worth, nor what a specific competitor might want to pay in a bidding war. The valuation must reflect an arm's length transactions where both parties are fully informed and neither is under a compulsion to buy or sell. And we can go to the next slide. So a buy-sell agreement is really only as good as the money backing it up. And if there's a triggering event that happens, like an owner passing away or divorce, and the remaining partners don't have the cash to buy out those shares, the agreement is effectively useless. So to prevent a cash crunch or a forced liquidation of the business, owners rely on some different funding mechanisms. Um, they're generally categorized into immediate funded options like using insurance, and self-funded or deferred options like sinking funds. Life insurance and disability buyout insurance. This is really the gold standard for unplanned structural shifts like death or permanent disability. It provides immediate substantial cash exactly when needed. And how that works is the business or the individual owners purchase the life and disability insurance policies on each other. And when a partner dies or becomes permanently disabled, the insurance company pays out a lump sum, which is then legally designated to purchase the departing owner's shares from them or their estate. This could be a cross purchase structure. So each owner buys a policy on every other owner. So if there are two owners, it's real simple. And owner A insures owner B and vice versa. And it's great. When you get more than that, there's this formula of n times n minus one on how many policies you need to buy. We worked with a family who was doing that, and they were bringing in a son, and the amount of insurance, they were like, can we do something else? Because they just didn't want to have all of the insurance. And the other thing too is you got to remember, especially when you're looking at a younger person coming into the business and an older person who's been in the business, sometimes that insurance isn't necessarily going to be feasible because the older partner is going to have a lighter insurance load than the younger person who may be trying to get life insurance on somebody who is significantly older, who may have, at that time, some discovered health challenges. So that can be difficult. Another option are, going to be the installment notes we talked about before. Um, and these promissory notes, these installment notes are the most common funding mechanisms for exits like retirement, resignation. They can be used for divorce, especially. This is when the remaining owners of the company make a down payment to the departing owner, and then the remaining balance is then structured into a promissory note paid out monthly or quarterly over a set period. Um, again, you can be draconian. You can say, hey, we're going to make this payout go on for 20, 30 years. But usually we're looking, at somewhere between 3, 5, 7, 10 years. And then doing that at a specific interest rate as well. This is a great way to kind of spread out the financial hit, especially when you think about some of the younger folks who may be buying out older generations in the family farm. It allows the business to also fund the buyout as well. The problem is the departing owner can take on some risk, and what happens if the business fails, the farm fails, are they ever going to see their money? And then, the sinking funds, using a accumulated cash reserve. This is very proactive. It's a self-funding mechanism. And so the business is regularly putting aside a percentage of its profits into, an interest-bearing reserve account, specifically earmarked for future buyouts. Very autonomous. There's no insurance underwriting. No interest payments to banks, no debt obligations. It's cool, but it does tie up valuable working capital that could be used to reinvest in the business. And then if a partner leaves or dies early in the company's life cycle, the fund won't have accumulated enough cash to cover the buyout. And then, of course, Ed was talking about traditional commercial borrowing, bank loans, things like that. Those can be used, and you just, when the triggering event happens, the remaining owners take out a commercial loan, and whether that person has good credit or not, that can certainly be an issue as well. But those are some of the different funding options. Next slide. So how do we fund the buy-sell agreement? Life insurance to fund entity purchase stock redemption. The entity is the applicant owner, the premium payer and the beneficiary of the policies on the lives of all the business owners. The cross purchase agreement, talked about that a little bit before. It's funded with life insurance used by the business co-owners, and you basically, in the agreement, you draft it up so that, and you say that when we are funding this agreement with life insurance, and when one of us dies, the survivor is obligated to buy out their shares, and the deceased estate is obligated to sell them at a predetermined valuation. So this is one of these things, again, when we talk about it, the business was worth $1 million. We're saying that we're going to use the life insurance, and that's going to be the valuation. And these are the policies that are going to make sure that the buyer buys and the seller sells, and we know what the execution date is. The triggering date is going to be that death, maybe that disability, and that benefit is going to be paid to the partner tax-free. And then that partner can use that tax-free cash to buy the other partner's share or interest in that business. And now the remaining partner owns 100% of that business. Again, highly effective. It can get complicated, again, depending on how many partners you have. And if you have, three siblings and three cousins, and they're all doing this together. That can be a lot of insurance. The cool thing is this does give a step up in basis. And so when the surviving partner buys the shares, their tax basis in the company increases by the amount they paid. And if they sell the business later, they will pay significantly less in capital gains tax. So that's kind of cool. The disadvantages, again, if you've got, say you have five partners, each of them has to buy four policies, and that means 20 separate policies. And again, if you have age or health disparities, especially when you have a partner who's, say, 60 and another who is 30, partner, the younger partner is going to pay much higher premiums. And so, one way, especially dealing with, the several partners there, is have the business again own that life insurance and set it up so that the business buys one single policy on each of the owners and then redeems those shares pro rata. And you can go to the next slide. All right. So, operating agreements. This is a core internal document for limited liability companies. You can think of it as a rule book that dictates how the financial, operational, and managerial decisions of a business will be made. And in all fairness, these generally, most states don't require you to file one with the government. Do you need one? So the government may not care whether you have this agreement, but operating without one can be risky. Without your own agreement, first of all, state law is going to dictate how your business runs by default. And your wishes may not actually align with state law. It's kind of like if you don't have a will, if you don't have a trust, if you don't have an estate plan, the state has a plan for you. And, your widow and your kids and how they divide things may not be how you actually want them to be divided. So again, having a plan, can work around what those laws might say. And so here's a breakdown of some just general standard provisions that you might see in a comprehensive operating agreement, ownership percentages and capital contributions. So who owns and how much does each person own? It's worth noting that ownership doesn't have to match capital contributions if the members agree otherwise. Some people may put in more money, but have less experience, for example. So what you bring to the table, it doesn't necessarily have to be equal for you to continue, though, to have, equal ownership. Adding capital, and are there rules for how the company will raise money from members if the business runs low on cash in the future? How are we going to allocate profits, losses, and distributions? So when and how profits are distributed to the members, or is it done quarterly, annually? Is it at the discretion of the managers? If there are losses, how are financial losses divided among the members for tax purposes? Distributions for taxes. Generally, you can use LLCs as pass-through entities, meaning owners are going to pay taxes on the company's profits on their own personal tax returns. So if that's not the case, or, otherwise, the agreement can often include a clause forcing the LLC to distribute enough cash to cover the taxes. Management structure and voting rights, LLCs can be member managed or manager managed. And if they're manager managed, the members can vote and elect who is going to be in charge and make those day-to-day decisions. or the members can all say, and have a say in sort of that day-to-day operation. Member managed when you have several members can kind of be a little unwieldy. And especially if you want to think about a farm where and some people, again, when we'll talk about fair and equal later, but if there are children who are profiting from the farm but have no idea how to run a farm, then does it make sense for them to be member managed rather than having somebody who knows what they're doing to be the manager? And then again, the operating agreement can include buy and sell transfer provisions, dissolution and winding up provisions, what's going to happen when the membership changes or when we finalize the business and wind that up. Next slide. So why is an operating agreement so valuable? Operating agreements establish formal business protocol. The idea of a limited liability company is legal protection from personal liability. And without the agreement, the LLC may only look like an LLC when it's actually just you individually doing it. And the appearance of the LLC structure may not be enough to withstand a lawsuit. So you really have to have behavior commensurate with your LLC structure for that personal asset protection, because the LLC, that limited liability company, that is taking your personal liability and sheltering it over here so that if something happens with the farm, somebody is injured by a tractor or something like that, then the liability doesn't shift to you. It stays with the business itself. And the single member myth, some folks will have their own LLC and they may think, you know what, I don't need an operating agreement. Again, if you have an operating agreement, it is a vital piece of evidence that proves your LLC is a legitimate separate legal entity from you and not just an extension of your personal banking account. And then the other thing that LLC owners can make a mistake is assuming they don't need the operating agreement because the state doesn't force them to file one. And yes, you can form an LLC without it, but again, it is important to show that you have that limited liability status, and it can be an important agreement to have for organizational reasons, and we can talk about that here on the next slide. Operating agreements can prevent and resolve partner misunderstandings. Misunderstandings can, destroy partnerships. And, when Ed was talking earlier, what happens when you sell the business or the business needs cash? What if one member feels like they're doing 90% of the work and they're only getting 50% of the pay? An operating agreement forces everyone to address uncomfortable what-if scenarios up front because it dictates exactly how voting works, how profits are distributed, how disputes are handled, and it turns emotional arguments into simple black and white contract resolutions. Because the Indiana Business Flexibility Act, which is the state's LLC statute, leaves room for interpretation regarding how members must treat each other, Indiana courts have had to step in and establish rules. For example, when courts get involved in multi-member LLCs, a majority owner will sometimes try to freeze out a minority owner, cutting off their access to financial books, refusing to pay them for their share of profits, or firing them from their job within the company. But courts are going to look at reasonable expectations of the minority members they're going to look at that agreement and step in to ensure that the expectations that are set forth in that agreement, and they are going to want to enforce reasonable expectations that people should have when they are entering into a business. And again, that operating agreement is going to establish a smooth exit strategy. Folks don't stay together forever, again, because of death, disability, just wanting to retire. Without the operating agreement, a departing partner could sell their ownership stake to an unknown outsider. So again, those buy-sell provisions and including those in the operating agreement can be really important. And so a single member owner can say, well, I'm not going to have a misunderstanding with myself. I'm going to be fine. Again, I still don't need this. But, going back to the banks and folks like that, they may want to see your operating agreement before opening accounts or providing loans so that they know that the business is serious and worth the investment. So permitted transfers. A permitted transfer could include a transfer to a trust or for the benefit of an owner member of their immediate family. And when we're talking about including permitted transfer language, and I'll be honest, nothing makes me happier than seeing permitted transfer language in an operating agreement when I'm putting together an estate plan. And the reason is that folks don't always do their estate planning first and then do the operating agreement. A lot of times, they create the operating agreement first and then they do some estate planning. With a permitted transfer, the operating agreement can say that other members are going to pre-approve moving ownership shares. So normally an operating agreement places strict limits on transferring LLC memberships. I mean, that's what part of this is for. We don't want somebody who shouldn't be a member to become a member. And what we want to do is say, look, there are some folks we're going to transfer to that are okay. That may or may not be a spouse, but often what it is it could be a trust. And especially coming from, an estate planning perspective, that transfer to a trust is critical in making sure the business interest can pass without going through probate. So if your trust can become a member of an LLC, then suddenly you have avoided the probate process for that business interest. And nobody has to know your farm's business, and things can be settled without court involvement. Another permitted transfer might include transfers to another business that they own. Say if you've got an LLC for the land and an LLC for the equipment, maybe those transfers are permitted, or transfers to existing members. So I could transfer my membership to my partner as well. So some common provisions in operating agreements, again, including in the business profile, the names of shareholders, business address, proof of registration with Indiana Secretary of State, the terms of capital contributions by the folks who are the members, owner titles and responsibilities, liability. Again, LLCs are to protect personal liability, and so we often include phrases in here to say, the members individually have no liability, and all liability is limited to the business itself. And then the authority of owners then to access LLC accounts, decision-making for specified responsibilities, voting powers, owner meeting schedules, etc. we're going to have personnel issues talked about, HR decision-making protocols, new business owner selection criteria, permitted membership transfer provisions that we talked about, the types of provisions that wouldn't trigger things like buy-sell, provisions or rights of first refusal. Ownership and compensation, how are profits to be shared, um, exit and entry terms, dissolution protocol. And again, we're going to sign and date that. And really, when we're reviewing draft agreements, the good rule of thumb is to look for the big three, who votes on what, who gets the money and when, and how does someone leave? And if those three elements are crystal clear, that goes a very long way, because if we know who votes on what, who gets the money and when, and how does someone leave, that is going to, end a lot of arguments and make a lot of clarity when we're talking about entities and succession. And then just some final notes and final thoughts. And Ed, you can join me on this after. Farmers face a lot of unique, complex challenges with business succession because a farm isn't just a business. It's a home, it's a lifestyle, a family legacy. It's a massive collection of highly illiquid assets when you're talking about, a combine and, parcels of land, livestock. When planning to pass a farm operation to the next generation or future owners, legal and financial structures gotta balance the needs of the business along with family dynamics. Following foundational strategies can help guide a smooth transition. So, again, separating operational assets from land assets can be a great way to uh, address some of the unique challenges. Putting the land in one legal entity like a land LLC and the farming operations into a separate LLC. That can create flexibility, and the operating entity can be transitioned to one child who's actually doing the farming, while the land can hold the land entity holding the real estate can be shared if it would, if you'd like. Um, Addressing the fair and equal dilemma early, I think, is real important too. And this is something I talk to clients about is what's equal. Let's say at the end of this presentation, you wanted to say, well, we're going to tip Ed and Scott $100. But Ed's, material was much better delivered than mine. So Ed should get more. If we shared it equally, maybe that's not fair to Ed. And so, what we want to do with, farm succession is understanding that there are going to be children who want to stay and run the farm, and there are going to be ones who don't. And if you divide the land and assets equally, non-farming siblings can inherit equal shares, they may inherit equal say-so, and that can, cripple the farming child's ability to run a profitable organization and to have their own um, livelihood taken away. And for kids who have been in the farm and working the farm and, have that sweat equity, you can't just say, it's harder to say, well, if everybody gets a third, if somebody has put their blood, sweat, and tears into the farm, that's important. And that's something that should be considered when we think about what is fair. And so we encourage clients to aim for equity and not equality, and passing assets appropriately, and then using other mechanisms, maybe life insurance policies or non-farm property or non-farm real estate that can go and provide inheritance to non-farming children. And remember to treat the transition as a process and not an event. Succession is not a single day where you just hand over the keys and you're gone. My dad is going to be one of those people. He is going to die on the tractor. He is a pine box farmer. He is going to be a farmer until the day he goes. That's just how it is. And, going back to, the difficulty of the farm isn't just a business, it's a lifestyle. That's it, it's not going to happen overnight. It just isn't. That when I retire from my life as an attorney, I'm not going to go to my office, and that's going to be very easy. When my dad wakes up in the morning, he's still on the farm. So understanding that and remembering that the transition is a process is really important. And then, get a multidisciplinary team in the room. Farm succession crosses a lot of legal and financial boundaries. And so you need a team to get together. And Purdue Extension is a great part of that team, having accountants as part of that team. Um, you want to have folks get together and work together to make sure that your wishes are implemented as you would want them. Ed, anything else you would like to add into our final notes?
Just you hit on a lot of really important things. That the way agriculture in particular is different with the cycles that go in agriculture, and how so many things can affect um, just with the current markets, and there's the variability that you have with interest rates and that type of thing. If you have somebody that needs to borrow money, that's something important to think about when you set this up. If there's how stable are they with their um, ability to actually be an owner and a manager. If they're currently and thinking about the different roles that people might play, and other outside people that are involved with the farming operation too, and it may not necessarily be a part of the farm, but actually could be an owner of some land assets, that type of thing, and having just the continuity of discussions between ever. So you do have the family members that are on track with and having some of those meetings that continue is important. And include who to include, who not to include sometimes is a bit of a challenge, with some of the discussions. But that's there again, if you have people that are owner and operators, and that are the ones that are going to be taking over the business, and that's important to make sure that thinking through the different changes that can occur throughout time with agriculture. So.
So at this time, if anyone has any questions, please feel free to type them in the box, which I think we just got one. So, do you have a suggestion on how to approach elderly parents and four adult children for a discussion? My brother is going to own farm and three sisters who knows what.
All right. So this is the question on how to approach elderly parents, and I'm going to guess this means about talking and getting things out in the open. Um, that's tough, because folks tend to want to be private, and depending on your heritage. My Lena Weber, you're going to guess we're German. We don't talk about emotions, and we don't talk about things, and having those conversations can be difficult. But I think here's the other thing too, is I've had some in the past week, I've had two deaths in the family. And there have been some hard feelings because people weren't honest at the very get-go about what was going to happen. Okay. So I think, approaching elderly parents as you do it gently and with love, and say, what we don't want is we don't want for there to be surprises and for there to be hurt feelings. And so this is an opportunity for you to put into words what your wishes are so we know what we're supposed to do and how we're supposed to manage things when you can't manage things anymore. And then after your death, because we want to do what's right by you and what you want. And just having that conversation. And then maybe there is a professional, an accountant, or an attorney that you work with that can help have that family meeting in a neutral place so that it doesn't have the connotation of, this is the traditional, family dinner, or this is where we have, Christmas and things like that, where you can go to a neutral location and have those conversations and share, what you want. And even sometimes having that professional deliver that news can take the onus from the parents, and then they can supplement and, um, have the obligation of telling people this is what the plan is, and having the parents then explain these are our thoughts behind that. And then letting the professionals talk about these are the tax implications. This is, these are the things that folks are going to have immediate concerns about. Um, a trust and estate with a POA has been done. Only the brother has a copy of the documents. Is it customary for everyone to have copies of all the documents? It is not customary for folks to have all the documents, and the reason is that elderly parents can change their mind about who's in charge. It's more common for folks to say, here's where the documents are. So it is generally not customary, but we do have clients who say, I want, all the kids to see it and have it opened up. But it would be unusual for everybody to have that. Um, you know, but encouraging them to have the meeting so that even if, um, so brother could share in a family meeting. Yes, brother could share in a family meeting. However, because he's a fiduciary, I would only share with the with the blessing of the parents.
All right, so some great questions and comments. Thank you, Scott, for fielding that so far. If anyone has any other questions or comments, please type them in the chat. I am going to share a link in the chat that is for tonight's survey. So if you could provide us with some feedback, that would be great. We use this for our reporting purposes with our grants. Again, everyone, please continue to type questions in the chat. Definitely, we want to thank Ed and Scott for joining us tonight and sharing a lot of really great information about operating and buy-sell agreements. Any final comments from either of you?
Thank you for having me. And Ed, it is so fun working with you and working with Purdue Extension on this and the business succession team. And it has been so fun to work with you folks out there. Ed and I were assistants to the basketball team at our high school together. And Ed was definitely the leader and continues to be the leader. And I appreciate his leadership with this. So thank you for having me.
Well, Scott is as he says, it's great. We've been able to make this connection after so many years, and help out a lot. I think it's certainly you don't find attorneys every day like Scott that are willing to that know agriculture and willing to that take somebody. And so I know there are attorneys out there that are willing to listen and understand, take the time to understand. And I think it's so critical having, that person, whether it's an accountant or attorney that can, be a part of that conversation as Scott mentioned. So, and it, just having that older generation recognize is also helpful too, and want to reach out to communicate with everybody involved, and it's not that they have to share everything with everybody, but willing to communicate. And so anything you can do on that part with the older generation, that's what I would say from my experience with family is very helpful. Just encourage that communication and recognize there are limits, but just having that encouragement is helpful.
Thank you both. And thanks everyone for joining us today. As a reminder, this session was recorded and we will send that out to everyone who was registered. We have our next session on July 13th. That one is on personal estate planning, and Scott is our presenter again. So again, thank you everyone. Enjoy the rest of your evening.